Hi, I'm Charles Vethan,
And I'm Cameron Weir.
and this is part of the Vethan Law Firm PC's video education series. Today's topic are the three pillars of asset protection.
So a lot of what we do here at the Vethan Law Firm is litigation. But litigation is what happens after two or maybe even three things have gone wrong. What we want to talk to you viewers here today about is some proactive steps that you can take to protect not only your company, but your personal assets.
Well, typically we have what we call the three pillars of asset protection. These are for business people who've, as you've said, spent a considerable amount of time building something. And what happens if a result of a judgment, a bankruptcy, an accident one of their employees had while they were on the job threatens the very existence of the business? So the three pillars of asset protection, as you said, was dealing with a company agreement. Second is dealing with testamentary documents. Those are wills and powers of attorneys. And the third is, at a certain asset level, talking about trusts, all designed to protect the company and protect the assets from those people who are trying to take it and protect the assets for those people with whom you are doing business.
So let's talk first about those company agreements. No matter what kind of company you have, whether it's a limited liability corporation, a regular corporation, or a registered limited partnership, you must have a company agreement. So a company agreement allows you to protect your business from the wrong people and to have it controlled by the right people.
What are some of the typical issues that we see that business owners haven't thought about when they create a company agreement?
Well, when you create a company agreement, you want to establish the roles of the people who are in charge of your company. So you're going to set up your officers and you're going to set up your ownership percentages. And it is very important that you delineate out who owns what parts of the company.
One of the issues we face, Cameron, is when there are two people that form a company, whether these are friends for a long time, family members, and they set up the company with a 50-50 ownership structure. While you may agree on 95% of how that company is to be run, what happens when there's an issue that one person sees it one way and the other person sees it another way? And pretty soon that becomes a focal point for conflict. So one thing we tell our clients is when you structure a company agreement, make sure you have someone who owns a majority of the business, even if it's 51-49%. Who will be in charge of making those decisions, those very few decisions, but critical decisions, if both of you can't agree?
And that's super important because we know that what happens when you have a deadlock is the other side can go to the court and ask that a receiver be appointed and control of your business. This isn't something that you want to have happen just because there was a deadlock over one particular issue.
Absolutely. So that's a voting issue. So we talk about how the company is controlled under voting. But as you mentioned, roles and responsibilities are important. Who's the person who's in charge of signing the tax returns? Who will be responsible for generating a profit and loss statement or a balance sheet to tell the other partners or the shareholders how the business is doing? And this is something that leads to a lot of disputes, is who has access to the bank accounts? Who can actually see the transactions that have gone through? What are some other items that some of our friends should consider when structuring an agreement?
Well, what a lot of our business owners want to do is incentivize some of their employees to work harder for the business. And you can accomplish that with a company agreement by setting up classes of shares. You can set up a list of key employees to get a percentage of the profits of the company without necessarily having any management control over the company, and so that you get those stock options back if they decide to leave the company ultimately.
And I think that's a generalized term called an employee stock option plan. This is not a formal plan like you have in larger companies, but it allows employees to be rewarded. If the company's doing great, then they should have a little bit of the profits. But if they leave the company, then the company is also allowed to buy back those shares because that represents control in the company. There are other types of companies that we work with. So basically, limited liability companies are becoming very popular, stock corporations, and registered limited partnerships. All three of them have different rules that apply within this general framework. Cameron, one thing we also look at is the fiduciary duty, and I think our friends can see some other videos we've done on that. Can you give us just a brief overview of fiduciary duties in a company?
Sure, absolutely. When you have the managers and the officers of a company, the law decides that they have a duty of loyalty, a duty of care, and a duty of candor. Now, these are all three very important because the loyalty means that they are not going to go and give a business opportunity that could have gone to the company to their own competing business. And the duty of candor means that they are not allowed to hide a interest that they are taking away from the company. And the duty of care means that they have to perform their management and officerial duties to the best of their ability.
And that's a great point to segue to our second pillar for asset protection, because one of the most important things that our business people want to know is what happens to my interest in a company if something happens to me? Is this something that I can pass along? And it's important to understand, Cameron, that goes into the probate arena. Like, should something happen to you, okay, then you have the probate court stepping in. And what should we be concerned about when you're looking at a probate court making decisions about the company?
Well, if you are not leaving behind a will that you have thought through the arrangements for, what you're actually leaving for your family is the potential for a fight rather than certainty and a clear plan of how your assets are to be distributed.
Okay. So that brings us to what we call testamentary documents. So typically testamentary documents involve wills, a medical power of attorney, a financial power of attorney, and a physician's directive. So as a business owner, you want as few items as possible to be passed through a will. Because if you have your decisions as to a company in your company agreement, a probate judge is not going to upset that. But if you want to address items in a will, address items such as a bequest or a devise. So a bequest is for personal property. A devise is for real estate, real property, typically. Two other things as a business owner you must have. And one is a medical power of attorney, and the other is a financial power of attorney. Medical power of attorney, sometimes people refer to it as a DNR, do not resuscitate. But you have to make a decision as to who will decide for you if you are unable to decide as to what to do if you're in a position that you can't make a medical decision for yourself. You're in a medical coma, a physician believes that you're not going to be able to pull through. Someone has to make a decision as to the next steps. Second item, financial power of attorney. You have to decide what powers you will give someone else to determine how to handle your financial affairs. Those are very important because that may be one person, that may be more than one person, and there are different times at which those conditions kick in. Third item, in addition to the will, fourth item actually, the will, the medical power of attorney, the financial power of attorney, is a physician's directive. And this is something that you're telling the hospital. So if your loved one cannot make a decision for you as to whether to pull the plug, if you will, then you've authorized a physician based on a reasonable medical probability to make that decision for you. So Cameron, which kind of leads us to, that's a second pillar of asset protection. The third one is for our friends who are in the higher tax bracket and asset classification, and they're looking at trusts. What does a trust entail?
Well, a trust is a distinct legal entity. And what a trust allows you to do is to put your assets into the trust to make them unreachable by any creditors, whether they are people who are seeking judgments against you personally, whether against your company, or whether against any of your beneficiaries who you are going to determine. So what we can help you do here is create what is called a trust declaration. In the trust declaration, you're going to make some very important decisions about what happens to those assets that you're putting into the trust. So first, you will decide what assets you're putting there. You will also decide who the potential beneficiaries are, and you will decide what the purpose of the trust is, and then you will decide on what terms those assets will be distributed to the beneficiaries.
With a trust, Cameron, a lot of people have heard about a trustee. What is a trustee? What is a beneficiary?
So a trustee is the person who you are giving charge of the trust operations to. So if you and your trust say that on my son's 21st birthday, he is to receive $200,000. It is the trustee's duty, fiduciary duty, like we discussed before, to make sure that the $200,000 that you have put into your trust is distributed to your son on his 21st birthday. So they are the person that actually does the things that the trust is supposed to do.
Now also, Cameron, depending on the jurisdiction of the trust where you set the trust up, sometimes those jurisdictions allow for a trust advisor or trust manager to help the trustee decide how to manage the assets in the trust. So in addition to whatever cash you choose to put in a trust, a lot of people put unique real estate in there. And this is for not just your present beneficiaries, but it's something that you plan for future generations. If you want more information on asset protection and how to protect the assets that you have built, contact us, because at the Bethlehem Law Firm, your problem is our business.